Hi, I'm Shan Wu. This is Under Color of Law, and we're going to talk about Donald Trump's attempt to ban birthright citizenship. So, like most of his executive orders, this is lawless and unmerited, but like all of them as well, it's been immediately hit by dozens of lawsuits now, many from state AGs, many from activist groups representing immigrants. So first, let's slightly rewind a little bit. And when Trump's nominee for the next Attorney General position, Pam Bondi, was during her confirmation hearings, was questioned about her position on this. And we're going to show why it's a obviously lawless and unconstitutional position. But let's listen to her reaction first.
Do you believe birthright citizenship is the law of the land, and will you defend it regardless of a child born in the United States, regardless of their parents' immigration status?
Senator, I will study birthright citizenship. I would love to meet with you regarding birthright citizenship.
Can I answer to serve as the Attorney General of the United States, and you still need to study the 14th Amendment of the Constitution? That is not helping me have more confidence in your ability to do this job.
So she basically says she needs to study it. Kind of an embarrassing follow-up there, saying that she doesn't even know the 14th Amendment. But let's take a look at what the law does say, just so we can understand just how ridiculous his executive order is. First, it's not just the Constitution, but it's also a law, 8 U.S.C. Section 1401. We'll put it up for you. And the very first example it gives is, quote, a person born in the United States and subject to the jurisdiction thereof. Okay, so that seems pretty darn clear. Now, let's examine what the Constitution, 14th Amendment, says. 14th Amendment, Section 1, put that up too. All persons born or naturalized in the United States and subject to the jurisdiction thereof are citizens of the United States and of the state wherein they reside. No state shall make or enforce any law which shall abridge the privileges or immunities of citizens of the United States. We go on to the Due Process Deprivation Clause. So, obviously here, Trump's idea of using an executive order to undermine this is both trying to use an executive order to overturn a law as well as the Constitution. So let's think about what that means for a second, okay? Executive orders can't override laws passed by Congress. Executive orders are limited to giving agencies, which are under the executive branch, further direction or some changes in policy, how they want to implement existing laws. You can't decree by executive order, okay, this law is no good anymore. That takes an act of Congress. Now, you can argue that the act of Congress is unconstitutional. You could have the DOJ make that argument, but that's not what he's doing, right? Okay, second of all, the executive order, sorry to laugh about this, the executive order cannot change the Constitution. You can change how you interpret the Constitution, but you cannot amend the Constitution by simply issuing an executive order. That's just completely silly. So let's talk about his perhaps interpretation of the Constitution. So the Supreme Court, that's its job, likes to interpret the Constitution. And there are two cases that have interpreted this aspect of the 14th Amendment. And they were also more recently reaffirmed too. Now the first case goes back a way, and it was the Wong Kim Arc case. And this was back in the 19th century. Wong Kim Arc, he was a San Francisco born cook, born in America. He'd left the country to visit relatives and parents in China, and when he came back, he could not get into the U.S. He was arrested, confined to the ship that he'd come in. 1895, this is. A customs collector, John H. Wise, kind of ironic last name, refused to recognize Wong's status as an American citizen, ordered him deported under the 1882 Chinese Exclusion Act, which prohibited Chinese labor immigration. One of the most racist laws in history, one of the only ones really to specifically target a racial class of people, similar to the Muslim ban, but that targeted a group of people from certain countries, perhaps on their religion. But this was aimed specifically at a race in 1882. It's during a period where there was enormous violence and racism directed at Chinese Americans, really stemming from economic issues. But it was a very difficult time for the Chinese Americans working and living here. Wong Kim Arc, he was only 21 years old at that time. He was the son of Chinese merchants who had entered the U.S. legally. But under the Exclusion Act, even though they came in legally, they were not allowed to become naturalized. Now, what I like about this story is, like so many other legal landmarks, they were brought by immigrants, by black people who had been enslaved, using the legal system to fight for their rights. So he fought against this illegal ruling, in his view. And the Chinese Consolidated Benevolent Association, which was a big civic group, then stepped in to help him to file a writ of habeas corpus that he'd been unlawfully detained as a native-born citizen. Case made its way to the Supreme Court, where in a 6-2 vote, the justices sided with him. And they said, quote, "The amendment in clear words and in manifest intent includes the children born within the territory of the United States of all other persons of whatever race or color domiciled within the United States." And with that, the court clearly made the point that you can't discriminate against him because of the fact that he's Chinese American. He was born here, born in the USA. Many years later, in 1982, the Supreme Court reaffirmed that same decision. In Filer versus Doe, they said, quote, "No plausible distinction with respect to the 14th Amendment jurisdiction can be drawn between resident aliens whose entry into the U.S. was lawful and resident aliens whose entry was unlawful." 3 years later, they did it again. This time, they had a case with married, undocumented immigrants. And the court said they'd given birth to a child who was born in the United States and therefore was a citizen of the country. If you want to take a deeper dive into this, we'll put up Steve Vladek's columns here, and he's a great resource for this and many constitutional issues. Then, in 1995, the Justice Department's Office of Legal Counsel also issued an opinion in which they were giving testimony before Congress, again pointing out that this was the correct reading of the Constitution, and any legislation that might try to change that would be unconstitutional. Now, interestingly, Judge Ho, who's a very conservative judge now, writing back in 2006, he wrote in an essay that, quote, "A constitutional amendment is the only way to restrict birthright citizenship." I think Judge Ho got that right. Recently, however, in a podcast interview, he was trying to backtrack a little bit on that. He was saying, well, this can't apply to a foreign invasion, quote unquote. You get where that's going, right? Now, that's going to be a failed argument because that's not what the Constitution says. There may be a carve-out if there was occupied territory, but that's not going to apply here. Let's talk about what that carve-out is, which is what Trump's folks are trying to rely on here. They're trying to rely upon this language of, quote, "subject to the jurisdiction of the U.S." So they want to say that, oh, if you are the child of an illegal migrant, then you're not subject to the jurisdiction of the U.S. So obviously there's a big problem with that, because one kind of stupid interpretation of that is, okay, well, therefore you can't even apply your laws to them. That's the whole point, right? You're subject to the jurisdiction of the U.S. if the U.S. can impose its laws upon you. So that's sort of a circular argument that really should lose on its face. But they want to tie that into this idea that there's a foreign invasion of migrants here. And that seems to be what Judge Ho is now trying to pull back a little bit on his 2006 writing. You know, maybe he's worried about preserving any potential elevation chances for himself. But unfortunately for this theory, foreign invasion was specifically contemplated by the Supreme Court opinion as well. So that's really not going to fly, or at least it shouldn't fly. What are the repercussions of this effort? If it succeeded, one, you'd have the point I made, which is you'd have to be conceding you don't actually have any legal authority over illegal migrants. Okay, that's sort of problematic. What's the more immediate effect? First of all, the fear of this happening makes the communities in a terrible state of being. It would deprive all sorts of government benefits for children. It would hurt their health care, it would hurt their food, their education, and if successful, it would really create a class of stateless children. I mean, their parents could arguably be, right, citizens of the country that they were born in and came across here without legal status, but the children would neither be citizens of that country nor citizens of the country they were born in. A remarkably cruel and unusual situation to put children in. Those are just some of those repercussions. This is going to be very hard to accomplish. I mean, like most of Trump's executive orders, they're meant to be stagecraft to make a point, but the repercussions are seriously damaging. The long-term effects of that succeeding are, of course, incredibly damaging to the very fabric of the country. But there's going to be a lot of legal fights about that, and we'll keep an eye on that. Good news is this kind of legal fight, while it's terribly damaging to people, puts fear in the communities, gives us a chance to bring into sunlight what the Constitution really says and what our laws really say, and reminds people of the lawlessness of the Trump regime. Now, just a couple of fun things to debunk. As has been put up on social media, we'll put it up here, great post, that J.D. Vance's wife would be ineligible for citizenship under his executive order. And there's an exception to that, but that's generally true. Something else to debunk is the following, that Trump's kids would be ineligible. That's not true. He's the father. We understand that to be biologically true. And he was a U.S. citizen, so even this order would not apply to them. In any event, the executive order supposedly is only prospective and not retroactive anyway, so it wouldn't apply to that. Still, those are sort of fun things to consider, and one does have to wonder what J.D. Vance is thinking when it comes to that, if he's thinking. So that's it for now, and good to talk to you. Hopefully you like, we redid the little set, some based on some of your suggestions with the lighting and such, and hopefully it's looking a little bit more easy on the eye. And thanks again for the comments and replies, and keep them coming. Talk to you soon.
In collaboration with the Midas Touch Network, we just launched the Legal AF YouTube channel. Help us build this pro-democracy channel where I'll be curating the top stories at the intersection of law and politics. Go to YouTube now and free subscribe at Legal AF MTN. That's at Legal AF MTN.